Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Today we're going to talk about my friend Rachel Tennyson's case. This is my private Facebook group, which is called Foreclosure Help 777. And if you're in foreclosure, you can join our private group, and we will share information with each other and help each other out so that you can stay in your house for as long as possible. Again, today we're going to talk about Rachel's case, and hers is in Texas. Let's take a look at a couple of things first. As you know, let's look at this one. As you know, she filed her quiet title action against them on March 19th. She filed her complaint in federal court against them. Problems with her chain of title and stuff. And if you look through her case, you'll see that the last thing filed was an amended complaint on May 8, 2025. The judge granted her motion for leave to file her amended complaint, and now they have 14 days from 5/8/25 to file a response. So you'll never believe what happened next, guys. Okay? You won't believe this. So the loan servicer is Loan Care, and the purported note holder is Lakeview Loan Servicing. And so if you look here, a new complaint was filed in the same court, in the same federal court. And they filed it on 5/14. A couple of days ago, they filed a complaint on her for, guess what, foreclosure. Now, usually they don't file foreclosure actions in federal court. But in this case, they did, because hers is a FHA loan, and they're actually suing FHA as well as a defendant to try to get it in the federal jurisdiction. So let's take a look at a couple things. First of all, her court cases, if you want to look at them, it's in Pacer, the Northern District of Texas, Dallas Division. And this case number for her new case is 325CV01232. And the other case number, her quiet title action where she's the plaintiff, the case number is 325CV00661. And as you can see, the same magistrate judge, Rebecca Rutherford, is on this case. And if you look at the new case, look who's the magistrate judge, Rebecca Rutherford. So this is an interesting situation. I can tell you, if you look at the complaint itself, it's very defective, and she should be able to get it dismissed very easily. Let's look at their complaint real quick here. Okay, so this is the caption here. As you can see, it's the Dallas Division of the Federal Court. And you can see the caption says Lakeview Loan Servicing is the plaintiff versus Rachel Tennyson and the United States of America on behalf of the Secretary of Housing and Urban Development is defendants. And if you scroll all the way to the end of this complaint and go up a little bit, you'll see the actual civil cover sheet. And you'll see here, where is it? Basis of jurisdiction. They check the U.S. government is a defendant. So you got to ask yourself, why would this law group do that? And it's one of the worst foreclosure mill law firms, Marinoski, how you say it, Marinoski Law Group PC in Addison, Texas. If you're in Texas, there's a good chance you're going to see these people going after you, guys, just so you know. Anyway, back to their complaint. Let's look at their complaint because it's interesting. Okay, so basically, they go right from parties and jurisdiction without factual allegations. They go all right to the breach of contract. And as you know, I've gone over many complaints with you guys. You know they have to be properly formatted, and theirs is not. They just go over breach of contract, and they have all these exhibits that they attach to it. And then at the end, they ask for a prayer, and then and that's it. But interestingly enough, they are mentioning another lender in here, which is Nation Star. And if you look at they're asking for attorney's fees. The loan provides that in the event of foreclosure, and insofar as allowed by Texas Rule of Civil Procedure 735, Lakeview may be awarded all expenses incurred in pursuing remedies provided for thereunder, including reasonable attorney's fees, costs, expenses, or advances made necessary or advisable as sustained by Lakeview because of the default, or to protect its security interest, Nation Star has retained Maranowski Law Group PC and has agreed to pay its reasonable attorney's fees and costs incurred relative to this proceeding and to protect Lakeview's security interest in the loan. Now, you guys, I don't know if y'all know this, but Nation Star is not in the picture anywhere. This is a typo that they did when they created their complaint. They should have put Lakeview as the servicer. And so this is one of those situations where they did a copy and paste and tried to change the names. And they screwed up because they didn't do their due diligence. But I guarantee you, if you look through all these exhibits at the end of the complaint, you're not going to see Nation Star anywhere because they don't exist in her situation. So these foreclosure mills, I know they have high volume, but I'm telling you, Nation Star is not in there anywhere. Okay, so let's see. What do you think that Rachel is going to do now? Let's take a look. She's going to file her motion to dismiss this complaint. And let's get a sneak peek. She's not going to file it just yet, but this is what she's going to be doing. So you can see that the beginning comes now. Defendant Rachel Tennyson, proceeding pro se, and respectfully submits this motion to dismiss under Federal Rules of Civil Procedure 12b-6 for failure to state a claim upon which relief can be granted. In support of this motion, defendant respectfully shows the court the following. All right. Background and procedural history. The case arises from dispute concerning title and enforcement of residential mortgage on defendant Rachel Tennyson's property located at 106 Dr. Martin Luther King Drive, Waxahachie, Texas. On March 19th, defendant filed a civil action in this court entitled Tennyson v. Loan Care, LLC, and there's the case number, seeking to quiet title and challenge the validity and enforceability of the mortgage loan and related documents. That action remains pending before Judge Ed Kincaid and Magistrate Judge Rebecca Rutherford in the Northern District of Texas, Dallas Division. A copy of the first amended complaint is attached hereto as Exhibit A. From April 15, 2025 to May 8, 2025, defendant Rachel Tennyson actively prosecuted the quiet title action, filing motions and an amended complaint on May 8, 2025, which added factual detail and reaffirmed claims challenging the lien's validity. On May 14, 2025, just 6 days after the amended complaint was filed, Lakeview Loan Servicing, LLC, represented by Maranowski Law Group PC, initiated a new separate foreclosure action in the same court under docket number, and there's that docket number, assigned to Judge Sam Lindsay. Lakeview's foreclosure complaint involves the same real property, a dispute over the same note and deed of trust, and parties with directly aligned interests, including Loan Care, LLC, named in the earlier case as the loan servicer. Lakeview failed to disclose the earlier filed case in its civil cover sheet, Section 8, or the complaint or its certificate of interested parties as required by Local Rule 3.3b and Federal Rule of Civil Procedure 7.1. Lakeview misidentified Nation Star as a party with an interest in the loan, which is a factual inaccuracy, suggestion, a boilerplate, or recycled pleading not grounded in the facts of this case. Lakeview sought to initiate judicial foreclosure despite the pending and unresolved quiet title action, creating a risk of inconsistent rulings and judicial inefficiency. Because of this procedural posture, the instant action appears to be a reactive, duplicative filing that should either be dismissed under Rule 12b-6 or transferred or consolidated with the first filed case under the first to file rule and the local case on management principles. Federal courts apply the first to file rule to avoid duplicative litigation and inconsistent rulings. Okay, and then it has some case law there. Because the issues and parties in the foreclosure case substantially overlap with those in the early filed quiet title action, Dismissal or transfer is appropriate under this doctrine. And you can see there's other cases there. Legal standard. To survive a motion to dismiss under Federal Rule of Civil Procedure 12b-6, a complaint must contain a short and plain statement of the claim showing that the pleader is entitled to relief. A plaintiff must provide more than labels and conclusions, and the complaint must contain enough factual matter accepted as true to state a claim for relief that is plausible on its face. And that's from Ashcraft versus Iqbal. And there's the other one, Bell Atlantic Corp versus Tombly. This is what everybody uses when they argue this, by the way. A claim is plausible on its face only when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. And again, mere naked assertions devoid of further factual enhancement are insufficient. Additionally, under Rule 10b, a party must state its claims or defenses in numbered paragraphs, each limited as far as practical to a single set of circumstances. This requirement promotes clarity and ensures a defendant has a fair notice of the claims being asserted. A complaint that omits key elements such as a clear statement of facts or that recites legal conclusions without factual support must be dismissed. Courts routinely dismiss complaints that fail to articulate a coherent factual basis or that rely on conclusory legal statements without supporting detail. Anyway, let's get to the good part here. Plaintiff's complaint suffers from these same defects because it omits a dedicated factual section, embeds factual references with legal conclusions, and fails to clearly allege how or when key events like default or acceleration occurred. Yeah, they're supposed to have a factual allegation section, and they just didn't have it at all. Plaintiff's complaint fails to comply with these basic requirements. It contains no clearly labeled factual allegations or background section, but instead jumps directly from parties and jurisdiction into the breach of contract count. Scattered factual references are embedded throughout legal headings, contrary to Rule 10b's mandate for organized and comprehensible pleading. The result structure is disjointed, conclusory, and deprives defendants of adequate notice of the factual basis for the claims. Accordingly, the complaint is deficient as a matter of law and should be dismissed under Rule 12b-6. Argument. Lakeview's complaint fails to state a plausible claim for relief. To survive a dismissal under Rule 12b-6, a plaintiff must plead sufficient factual matter to nudge its claims across the line from conceivable to plausible. And then it says, Lakeview's complaint fails this test. It recites bare legal conclusions that the borrower defaulted, the notice was sent, and that the loan was accelerated without setting forth specific facts supporting those conclusions. Plaintiff alleges that it sent a notice of default, but fails to identify the specific date of the notice, how it was delivered, as required by the deed of trust, what cure amount was demanded, and by what deadline. Plaintiff failed to comply with all contractual and regulatory preconditions to acceleration and foreclosure. Plaintiff's complaint fails to allege compliance with all contractual and regulatory preconditions to acceleration and foreclosure, including proper notice of default and an opportunity to cure. Under Texas law, a lender must strictly comply with these conditions precedent before initiating foreclosure proceedings. Failure to do so renders the foreclosure action defective and may deprive the court of jurisdiction to adjudicate this matter. See Mitchell versus Armstrong Capital Corp., which is a great case if you ever get a chance to read it. It's really good. It's holding that unresolved title disputes can deprive courts of jurisdiction over possession claims arising from foreclosure sales. Without these factual underpinnings, plaintiff's breach claim amounts to a recitation of elements and exhibits and not a properly pleaded cause of action. Without these facts, the court cannot evaluate whether a valid breach occurred or whether the lender met all conditions precedent to acceleration and foreclosure. As courts consistently recognize, a breach of contract claim must allege all essential elements, including performance by the plaintiff. And then there's another case which states, to prevail on a claim of breach of contract, the plaintiff must prove performance by the plaintiff or some justification for non-performance. Here, plaintiff does not allege that it fulfilled its own obligations under the note, deed of trust, or applicable HUD servicing requirements prior to acceleration. Absent this, the claim fails as a matter of law under Rule 12b-6. Improper and conflicting party references. Nation Star. This is a good part. Despite never being named as a party, Nation Star is referenced repeatedly in key paragraphs relating to standing, damages, and relief. See paragraphs 13, 14, 15, and 21. For example, it states, borrower continued breach under the loan has directly and proximately caused damages to Nation Star. This apparent error undermines the credibility and integrity of the pleading. It creates confusion as to who actually owns the debt, who suffered harm, and who is entitled to enforce the contract. The court cannot enter a plausible standing based on such errors. Misleading certificate of interested parties. Lakeview's certificate of interested parties fails to identify Nation Star, even though the complaint claims that Nation Star is a party damaged and entitled to fees. This contradiction suggests a lack of due diligence and creates an additional layer of confusion over who actually owns or services the loan. It undermines transparency and may mislead the court. This complaint should be dismissed under Rule 12b-6 because it lacks a coherent and properly formatted factual basis, contains material misstatements about the real parties with interest, and omits related litigation in the same court and fails to plead sufficient facts to support a plausible foreclosure claim. The attached exhibits contradict key allegations in the complaint. This is good too, guys. A complaint exhibits are considered part of the pleadings under the Federal Rules of Civil Procedure 10C. When a complaint allegations are contradicted by its own exhibits, the exhibits control. The court need not accept as true allegations that contradict matters properly subject to judicial notice or by exhibit. Here, while Lakeview alleges that Nation Star has incurred damages and retained counsel, see complaint paragraphs 13 and 21, none of the attached loan documents identify Nation Star in any capacity. Instead, the exhibits, including the note, deed of trust, and modification agreement, only name Loan Care as the mortgage servicer or contact party for borrower communications. This directly contradicts the complaint's repeated reliance on Nation Star as the injured or servicing party. This calls into question of who is the true party in interest is, whether the claims were asserted by a party with standing, and whether the factual foundation of the complaint was even reviewed by counsel before filing. Because these internal contradictions go to the core allegations, default, damages, servicing, and exhibits do not support but rather undermine the claims, the complaint is subject to dismissal under Rule 12b-6. Conclusion. For the foregoing reasons, the defendant respectfully requests that the court dismiss plaintiff's complaint in its entirety pursuant to Rule 12b-6 of the Federal Rules of Civil Procedure. Plaintiff's complaint is legally and procedurally defective. It fails to set forth a clear and coherent factual basis as required under Rule 8 and 10, instead presenting conclusory allegations under legal headings without organized or labeled factual section. The complaint inexplicably identifies Nation Star Mortgage as the injured party in multiple paragraphs, despite attaching exhibits that show Loan Care as the actual loan servicer, a contradiction that undermines plaintiff's standing and factual basis for relief. Critically, plaintiff failed to disclose a related pending action nearly 2 months earlier in this very court, which involves the same property, substantially overlapping issues of title and foreclosure and plaintiff's own loan servicer, Loan Care. This omission violates Local Rule 3.3b and raises concern about proper forum manipulation or attempt to avoid judicial officer already familiar with the facts. Given these substantial deficiencies and procedural irregularities, defendant respectfully submits that this complaint should be dismissed with prejudice, and the amendment would be futile because the claim is based on fundamentally inconsistent allegations and omits its essential facts and parties central to plaintiff's own cause of action. All right. Wherefore, defendant respectfully requests that this court grant the motion to dismiss plaintiff's complaint with prejudice and grants such other and further relief to which defendant may be justly entitled. And as you can see, she's going to file this electronically when she gets ready to. So You know, it's really odd to see a foreclosure complaint in federal court anyways, because usually they're filed in the state, or in Texas situation, they do a non-judicial foreclosure. So I think it's really interesting that they're doing this. And so hopefully the game plan is, you know, because they filed this in the federal court, that means they can't do a non-judicial foreclosure and just sell her house. They'll have to go through this whole thing. And I told her, I said, you know, that's a good thing, because as long as you can keep this going in court for as long as possible, then they can't sell your house while you're fighting your other case. So there's that. Okay, guys, I hope this was interesting and educational for you guys. As you know, I am not an attorney. I can't give legal advice. I'm just a homeowner that fought my own foreclosure, and I like to reach out and help others fight theirs. If you have any questions or comments, you can leave them in the comment section below, or send me an email if you have any questions about your own situation. My email is foreclosurehelp777@gmail.com. It's spelled just like this with the number 4. foreclosurehelp777@gmail.com. Okay, I hope that you guys have a wonderful day, and God bless.